Good afternoon. This is John Richardson speaking with you from Toronto, Canada. Today is Thursday, January the 20th, 2024. And on this day, June 20th, 2024, the Supreme Court of the United States has finally handed down its decision in the Moore case. And I maintain that this is still the single most important decision the court has ever decided. But that aside, there are a lot of aspects of it that do need to be discussed. And joining me today is Laura Snyder, who, of course, was at the hearing and got a close up look at all of the justices, all of the lawyers. And we even did a podcast debriefing her after that. Laura, how are you today?
I'm good, John. I got to look at the justices. I got to look at their faces. The lawyers I only saw from the back.
Well, that's better than most people. Have you ever seen the original, the movie Top Gun? The first movie?
I have not.
Oh,
I have not.
you really got to go out and see it because it starts out that the whole, as you may know, it's about this Tom Cruise plays this character going to a naval flight school. And the only reason he's sent is because in an earlier episode, he had a close-up look at a Soviet MiG, right? So that was the reason. And I think there may be a direct analogy here. You had a close-up look, one of the few people, a close-up look at what was going on in that court. Good analogy?
Sure. Okay. Yeah.
So there you go. You're in a privileged position with all kinds of stuff. So let's just begin generally. So what happened today anyway? So finally the decision comes down. What happened?
You mean what happened in this case? Is that what you mean?
Yeah, on the Moore case.
Well, okay. It's only been a few hours. I have definitely not had time to digest this case. And to be honest, I don't know if I spent an unlimited amount of time on it, if I would fully digest it. Probably not.
Well, how about this? Did the Moores win or lose?
The Moores lost, but 7-2, and there were basically three different. There was the opinion of the majority, there was a concurring opinion, and there was a dissenting opinion. Did I leave anything out of that, John?
You absolutely did not. That is fantastic, especially since it's only been out 3 hours. Okay, but before we get into the content of this thing, there were a lot of amicus briefs. There was a lot of interest in the case, and of course, SEAT put together an amicus brief. And you would agree with me if I were to say that a principal purpose of SEAT's amicus brief was to demonstrate the horrific effect that the transition had not only on individuals, but especially on Americans abroad, right?
Yeah, yes, that was the purpose of our brief for the tradition tax. And our brief was not the only one to do that. There was also a brief drafted and submitted by Lawyers for Winston and Strawn. So there were two briefs along those lines.
All right. So in other words, there was absolutely no question, but that the court had evidence of the horrific effects of this retroactive tax on individuals generally and Americans abroad specifically in front of them. No question about that, right?
Not just the court, but the parties knew it too. The parties knew it too, but the court definitely knew it. Yes,
and everybody knew it. Agreed.
The parties had our briefs before they filed their final briefs. Everybody knows it. Yes, it was never a secret.
All right. Now, I realize that the decision's only been out 3 hours, and you probably only read it 5 or 6 times at this point, right? But was there any reference at all in any of the decisions to individual shareholders, let alone Americans abroad? Was there any reference at all?
Not at all.
All right. So you would say that. Oh, and by the way, I wanted to ask you another question. Now we wrote an article a while ago. I can't even remember what it was, but part of the article demonstrated beyond a shadow of a doubt there were far more individuals impacted by this tax than corporations, right?
Okay, so this is discussed in 2 articles. One was the article that you and Karen Alpert and I did, which is called "Don't Blame the Victims: Individuals in the MRT." And then another article that I wrote, "The Invisibility of the American Immigrant." There, in both of those articles, there's a discussion about the fact that, yeah, I mean, more individuals were affected by this tax than corporations were. And including in that is an admission, albeit I don't think a purposeful one, but an admission by the lawyer who argued for the government in this case that was exactly what the case was.
In other words, even the Solicitor General of the United States was aware of this when she
Yes.
made the arguments, correct?
Yes, yes, because she said at one point she said that more corporations were affected by this, and then later she corrected herself, unprompted. She went back and corrected herself, so she knew she had made a false statement.
She knew she was trying to mislead the court, correct?
Yes.
Okay, I think there's no doubt about that. All right, so what we have is a situation where, as a matter of simple fact, the vast majority of taxpayers affected by this were individuals. Of those individuals, a vast majority of those were very likely Americans abroad. The Moors themselves were individuals, yet this decision comes down without even an acknowledgement that individuals were affected and were affected very differently from multinational corporations. Agreed?
Yes, even the Moors themselves were not served in this. They were just, being used by whoever was funding this lawsuit. Because even, the lawyers that argued on their behalf was entirely focused on corporations. The fact that the Moors were individuals just didn't even enter into their discussion. Which, in which case, you can say, why should it enter into the courts? I mean, certainly that's the court's attitude, because you see that the court, another argument that the Moors could have brought, and they did bring it in the lower court, was about the retroactivity of this tax. And they did bring it in front of the Court of Appeals, if I recall correctly, but did not bring it to the Supreme Court. And the Supreme Court says in footnote 6 in this opinion that they issued today, well, retroactivity was raised in the lower courts, but not raised before us. And so we're not going to talk about it. And why should we? So you can only imagine that that's their same attitude towards the question of individuals. If neither of these parties are going to raise it, then the court's not going to raise it either. And to me, this is just yet more evidence, as if anyone needed more, that not only is the Supreme Court completely controlled by corporate interests, but the cases that come in front of the Supreme Court, who brings them and how they're brought and how they're argued, is also completely controlled by corporate interests. Individuals don't have the resources to do this. Imagine the resources it takes to get a case in front of the Supreme Court.
Yeah, I think there's absolutely no doubt about that. I mean, just the amount of work that went into getting the seat amicus brief, created and filed was, I think clearly well beyond the capability of the vast majority of humanity, right?
Well, it certainly wasn't easy. I'll agree with that.
It wasn't easy. I'd like to read footnote 6 into our discussion here, okay?
Okay.
Exactly what it says, all right? So the MRT, by the way, that refers to mandatory repatriation tax that we've been calling the transition tax. Applies to income that was realized and accumulated in the past by foreign corporations, but not taxed by the United States. In the lower courts, the Moors raised a due process retroactivity argument that the MRT taxes income that was earned too far in the past. The Ninth Court rejected that argument based on the court's decision in the United States versus Carlton, and the Moors did not seek certiorari on that issue. We do not normally consider a separate legal question not raised in certiorari briefs and see no reason to make an exception here. Okay. Now, I want to come back to that when we talk about Justice Coney Barrett's decision as well. But I think this is very, very important because for whatever reason, the Moors lawyers decided to abandon the retroactivity argument on the certiorari application of the Supreme Court. I mean, obviously, I'm not asking you to get inside the head of, the Morris lawyers. Actually, I think I will. Why do you think they would have abandoned that?
Well, can only speculate here, but and I'm sure you can have your own opinion, John. But my speculation would be because if the court latched onto that, which very well might have, it wouldn't give the people behind this lawsuit the decision they really wanted, which is apparently something that will make a wealth tax more difficult. A retroactivity argument won't do that. That's my guess.
Yeah, I think you're 100% right on that. 100% right. That I don't even think they cared about the transition tax issue at all. Their focus was on, at least I think, oh my God, look, this is a situation of trying to impose direct taxation where, income hasn't been realized, right? I think that was their focus. And I think probably they were worried about a wealth tax. But it is interesting to me that the majority decision has a footnote 6 in it, explaining why they're not going to deal with retroactivity. And certainly in Justice Coney Barrett's decision, she also says that there are due process issues that I would presume would include retroactivity that she wasn't going to get into simply because they weren't raised. So, interesting stuff indeed, and not that it matters what I think, but I've always thought the retroactivity argument was by far the strongest argument if one were really interested in getting rid of the transition tax. But in any case, all right, so here we have this decision, and by the way, before we go further with this, I mean, our audience is mainly Americans abroad. You would agree that this is a very, very frightening decision for Americans abroad, right?
I would say that it just underscores that if you're not at the table, you're on the menu.
Okay, yeah, okay, put it that way. Would you? I
Yes.
know you're not. I know that
Well,
you're not. I know that you're not a fan of renunciation. But if somebody
Well,
were thinking about renunciation, would this be a good argument to renounce?
you're right. Well, what I'm not a fan of it. It's not something I push, but I think it is, further proof that we are invisible, which is, why I wrote an article with that in the title, that we really are invisible. And the last part of that article talks about how we're invisible in the context of this specific case of Moore. And if we are invisible, then anything can be done to us. If we are really just going to be, set aside, overlooked, ignored. And I guess let me say another comment about this case in this context. So if you look at commentary on how the Supreme Court has made decisions with respect to federal taxation, the general consensus among this academic commentary is that the Supreme Court practically never strikes down any federal income tax provision. And in fact, they will say they never have since Macomber, which was 1920 something. Now, I would dispute that. I think that the Windsor case was based on a tax provision, and it was a lawsuit with the IRS. And as a result of the Windsor decision, an estate tax wasn't due. So, and that's a recent case, relatively recent, from 2012. So I have a little quibble with that general consensus. But the general consensus is that in cases like this, where the arguments were poorly made, so many arguments that could have been brought and should have been brought were not brought. And so this case is decided on poor arguments, is only going to fuel this impression that everybody has, the Supreme Court's just never going to strike down any sort of federal tax provision. And this is what is so dangerous for us, because we are not going to get our problems are not going to be resolved by Congress because of the prejudice and discrimination that led to these very laws. And we're going to have to bring a case in front of federal courts claiming violation of our equal protection rights. And what are we going to get back immediately? Even by people who claim to be sympathetic, oh, well, that's never going to work because the Supreme Court or the federal courts never will decide, against the government in a federal tax case. Well, yeah, if you're bringing bad cases with bad arguments, yeah, I guess so.
Well,
So yes,
look,
long answer to the question, John, is it's dangerous.
Yeah, it's dangerous. Well, I mean, to sort of, pair this with, discussions over the last few days. So obviously you would agree that the only solution to this problem is severing citizenship from tax residency. Agreed?
Yes, John.
All right. And you would agree that these groups out there need to be arguing that and not all this peripheral stuff, right?
Yes, John, but we are in a minority. But yes.
Okay. All right. So for the people who are thinking of renouncing, I think it really, really strengthens the suggestion that all roads lead to renunciation now. I bet there's an awful lot of people today who wish they'd renounced years ago. That's for sure. Okay, let's move over to the decision itself to some extent, anyway. Oddly enough, I'm more optimistic about this than everybody else I've talked to, which I'll explain in a minute. But could you help me with this? So what did the Ninth Circuit rule that, effectively got this thing in front of the Supreme Court?
You'll remember better than me, but wasn't it that the realization wasn't required?
Yeah, I think that's right. Okay. That was I think, the straw that broke the camel's back. I mean, it's like they could say anything they wanted. And then to conclude with realization is not a requirement for taxation. I mean, that's unbelievable stuff, right? I mean, that seems to suggest that the government can just say, let there be income. And there was income, whether you got it or not, right?
Yeah.
All right. So that seems to be the basis, okay, that of the certiorari petition. Of course, it's clouded with all kinds of constitutional clutter, et cetera, et cetera. But the real issue was whether there's a constitutional prohibition on the government imposing taxation when there's been no realization of income. Would you agree with that?
Yeah.
Okay. Now, do you have any sense of what the majority did, or do you want me to?
You should definitely, John.
And you can chime in.
You do. You go.
Okay. And please chime in. Okay. So what we have of 9 judges is 5 judges in a majority opinion written by Justice Kavanaugh, who, by the way, during the hearing, I think made it very, very clear that he was going to uphold the tax, right? Joined by all of the Democrat appointees, interestingly, right? Other than Justice Roberts, you can almost see this coming down on, and whether these judges were appointed by Republicans or Democrats. But what you have here is 5 judges, okay? And what I think they did was they said, you know what? We don't need to even decide the realization question here because there was realization, right? Would you agree that's the first thing they did?
Yeah, sure, yeah.
Okay. And then they went on to look at all the, the precedents over the years. And they said, look, everybody knows there was realization. The United States has a long history of attributing income realized by corporations to other people. And there's nothing about this case that makes it any different from any previous forms of attribution, subpart F, etc. So, this is all good stuff, right?
Yep,
That's what they did, right?
yep.
Now, noting for the moment, because I think this is very relevant to Justice Thomas's decision, would you say that that court actually addressed itself to the question of whether realization was required?
Not that I could tell.
No, they didn't. Okay, they simply didn't. Okay, they started off, it was just like Justice Roberts at the hearing. First thing he said was there was realization. So now here's what they say, sort of towards the end after, hang on, let's get down to the end here. After going through this upside down, sideways, diagonally, here we go. To sum up, the court's long-standing precedents plainly establish that when dealing with an entity's undistributed income, Congress may tax either one, the entity, or two, its shareholders or partners. Okay, so they say that. And then they move sort of, where's the conclusion here? I mean, it's funny, they don't really say much different. I mean, they go on about it, but God, this is so long. How could anything so long say so little? Yeah, then they say right at the end, the Moores argue that realization is a constitutional requirement. The government argues that it is not. Now listen carefully. To decide this case, we need not resolve that disagreement over realization. I mean, they're clearly not even answering the question, right?
Yeah.
It's worse than that. They're not willing to address the question. These are potential issues for another day. And we do not address or resolve any of those issues here. As to the Moores case, Congress has long taxed shareholders of an entity on the entity's undistributed income. And it did the same with the MRT. The court has long upheld taxes of that kind, and we do the same today with the MRT. We affirm the judgment of the U.S. Court of Appeals. Now that's interesting. I would say they confirm the result of the judgment of the Ninth Circuit. But what they did not do was address the key component of that judgment, which is that there's no constitutional requirement of realization, right?
Mm-hmm.
So that's interesting. I mean, I thought it was, it's the type of thing that, I mean, obviously I haven't had a chance to go over this with a fine-tooth comb. It just came out a few hours ago, but that seems to be the bottom line. It's just sort of a two-part thing. Hey, there was realization. Foreign corporation realized this stuff. Then they move to the end and just say, well, we don't need to decide the disagreement over realization because there was realization. And all right, so we know that once there's realization, that income can be attributed to somebody else. That's all it is, right?
Yeah. When you go back over this, John, I'd be interested to have your opinion on a couple aspects of this majority opinion. First of all, at least twice, they infer, if not state outright, that the income of the corporation that's being attributed to the shareholders, they say the entity itself has not been taxed on that income. And at one point, I think it's even not so ambiguous. I think that they're suggesting it wasn't even taxed by the country where the corporation is located. And I thought that's a pretty sweeping statement to make and assume. I mean, a lot of other countries have corporate income taxes. I didn't understand where that came from, where that statement came from. So I'd be curious to have your opinion on that. And the other is there's a moment in this decision where they're describing the purpose of the MRT, and they say it's to encourage companies to bring their earnings back to the United States. So yet again, you have a blatant, just let's pretend overseas Americans do not exist. because under what circumstances is the earnings of their small businesses in the countries where they live supposed to be repatriated to the United States? It's just a completely nonsensical, and all that is completely ignored. Anyway, those two aspects, John, when you have the chance to go back and look at this, I'd be interested to have your opinion.
That's very, very interesting. I mean, I think that their view would be that, as we all know, U.S. citizenship is a property interest in the individual. Therefore, if as a U.S. citizen, you're owned by the government, and the government owns what you own, right? I mean, I think that's how they would probably explain it. But isn't there also a rather a political paragraph or two where they say, "Oh my God, if we were to sign otherwise, Treasury would be deprived of all this revenue"?
Yeah, that's in there too.
I mean, that's pretty disgusting, isn't it?
On multiple levels.
So
well, I think the dissent points out one level on which that's disgusting, which is, okay, because Congress has done something very bad for a long time, we can't change it because it's gone on for a long time. And I mean, really, that seems to give permission to Congress to do anything. And I think it also underscores this problem with the Supreme Court in terms of who's making the decisions and how cases get in front of them. There's many cases that could have been brought before the Supreme Court to challenge a lot of these things, but who has the resources to do it?
Well, I think, Laura, that this is kind of what I expected, and I think the true significance of the decision is the irrelevance of the individual in America. I found it fascinating this morning, looking at the New York Times. There was an article about, the important Supreme Court decisions that have come down this year and the remaining ones to come down. And this one wasn't even listed as an important case. And to me, that suggests that Americans simply believe they're nothing but taxpayers. And that they may have peripheral rights, little skirmishes in the area of whether, they can own a gun or not. But in the issue of whether they have any autonomy in terms of things like taxation, no, absolutely not. They're completely owned by the United States. I mean, the very fact that this so very important case was omitted in a discussion of the important decisions yet to come down. I mean, I find that, I don't even know what the word is, but don't you find that significant in some way or another?
Yeah, I mean, I don't, of course, among the tax community, people considered it potentially the most significant case. But sure, outside of that, people, weren't paying attention to it and probably considered it quite technical.
Well, yeah, okay. Interesting anyway. It's a complicated case to understand. If you look at the comments on the New York Times article today, it's clear that nobody has any idea what it's about. It doesn't, of course, change everybody, the fact that all these people have definite opinions about it, but they don't know anything about it. But here let's skip over Justice Jackson's sort of opinion to reinforce the majority. Okay. I mean, she did sign on to the majority opinion, I think. Let's move over to Justice Coney Barrett and Justice Alito. And what they did here. You want me to go first, or do you want us to go first, or?
Yeah, you go first. Definitely with Barrett's, because that one I got a little lost in.
Okay. So, keeping track here, right? So we have the 5 in the majority, right? Are really saying, we're not going to address the question of whether realization is required. There was realization, and we're just going to say, well, Congress can attribute it over. That's it, buddy. That's it. Why are we wasting our time? Now, what's interesting to me is when I think back to the arguments, this is completely consistent with Justice Barrett's arguments or questions during the hearing. Okay. Because do you recall Justice Barrett getting into the issue of just how much ownership in a company should be required before it's okay to attribute the profits of the corporation to the shareholder? Do you recall that?
I do not. You have a better memory than me.
No, I don't know. I think we all just latch onto the things we find most interesting, but she was really focused on that. And that particular line of questioning is really what her decision is about. Now, she's joined by Justice Alito. Okay. Joined by Justice Alito. And what she says is, okay, we're going to uphold this tax, but the reason we're going to uphold it is because the due process issues were never really briefed. Okay, and with a strong implication that had they been briefed, that this might actually have come down very, very differently. Okay. Now there's a lot of technical gobbledygook here. I mean, part of the problem, part of the reason why it's so hard to read this stuff is the attempt to tie all this stuff to the history of the the 16th Amendment stuff. And this is where I get really kind of lost in this and less interested in it, because I don't think that has a great deal to do. But what she says, I'm trying to find the part of this. She says, all right, yeah. I mean, she agrees that there was realization. Okay, so you start with that. But her issue is, that's only the beginning of the inquiry. Okay, that's only the beginning of the inquiry. The other question is whether the attribution of that income to the individual violates some kind of constitutional due process standard, right? Do you think I'm on the right track here, or do you have no?
Keep going. I don't keep going.
Okay. Let me just see what I can find here. All right, so she's saying a couple of things here. One is that although she seems to agree there was realization, okay, she doesn't seem to me to be going quite so far as that any realization anywhere under any circumstances is going to count as realization for the purposes of meeting a constitutional standard. Then she goes on, I'm trying to find this paragraph. She actually says that there are due process issues here that were simply not addressed. And let me just see here. Okay, starting with, today the court does not dispute either that income requires realization or tax on, oh God, this is too technical. I can't find the, this just goes on and on. I can't find the exact paragraph I'm looking for. Okay. All right, here we go. Although I believe the court today is too quick to bless the attribution of corporate income to shareholders, its holding is narrow. The court affirms Congress's power to tax shareholders on the undistributed income of American-controlled foreign corporations, but it says that trouble scrolling. Okay, here we go. Here's the critical sentence. Our precedent does not give Congress carte blanche to attribute corporate income to a shareholder. Instead, it suggests that Congress has a limited power to do so that depends on the relationship between the shareholder and the income. Okay, although I believe the court today is too quick to bless the attribution of corporate income to shareholders, holding is narrow. Let's see, going on here. Yeah, okay, so I found it. All right, here's the paragraph. Although I believe the court today is too quick to bless the attribution of corporate income to shareholders, its holding is narrow. The court affirms Congress's power to tax shareholders on the undistributed income of American-controlled foreign corporations. But it says the due process clause cabins that power by requiring income attributions not to be arbitrary. The arbitrariness inquiry the court previews turns on the taxpayer's relationship to the underlying income. I agree that the Constitution prohibits Congress from arbitrarily attributing to the taxpayer someone else's income. Our cases have located that limit in the due process clause. But an arbitrariness limit is implicit in the 16th Amendment too, going on and on and on. Anyway, that's the bottom line there, right? So what she wants to do is get into the question of, assuming there was realization, what might the constitutional limitations be on attributing that income to an individual shareholder? Now, I think that is actually very, very good news, because would you agree that at a minimum that her decision is saying there may be constitutional limitations to attribution?
Yeah, I'm not sure what those would be.
Okay, well, we don't need to decide what they would be to recognize that she says there may be constitutional limitations. So what we have here is 5 judges saying there was realization, it can be attributed, and we're not going to get into the issue of whether realization is required at all. We're going to stop there. Agreed?
Yeah.
What she is saying, joined by Justice Alito, is, yeah, there was realization in this case. Okay, with reserving the right to decide whether there would be realization in other cases. But as a further component, there are due process issues with respect to if there's a realization, when that can be attributed to a shareholder for constitutional income, right?
Mm-hmm.
That's, I think, incredibly important. I think that's the silver lining here. It doesn't help Americans abroad. It doesn't help the Moors. But what it does do is it helps people who want to go up against the argument that, well, it's a tax case and therefore the Constitution doesn't apply, right?
Mm-hmm.
Or do you think, I gather from your tone, you think I'm too optimistic?
No, I was just thinking about what you said. I mean, I'd like for you to be right about that. That it's only 2 people that signed on to that.
Well, not really. Okay, the way I see this. I actually see this. I know that people think I'm crazy, but that's all right. I see this as a 4-0 decision in favor of future taxpayers. Okay, the majority just wanted to, not upset the apple cart, give the US Treasury all the money, forget about individuals, let them confiscate individual assets. That's what the majority wants, right? Okay. Not, deliberately avoid the question of whether realization is required. This, although agreeing with the result of the Moore decision, says, no, not so fast. There's a constitutional question of what might constitute realization, although in this case there was realization. But hey, there's also a constitutional due process argument with respect to whether that income can just be attributed, right? I mean, the majority just attributed the income to the shareholder. What she's saying is not so fast. All right, there's a separate inquiry here, and that is whether that income, even if realized, can be constitutionally attributed to the shareholder. She further says, we're not going to get into that here because, well, the lawyers never raised it as an issue. But just for the record, okay, we're not going to rule out the possibility of there being constitutional limitations to this attribution. Isn't that what I think that's what it's saying.
Yeah, but it's still only 4 people.
But the only people who address the question, Laura, are coming down on this side. It's 4-0. You see, the majority just said we don't want to deal with that as an issue. They never said it wasn't an issue. They just said, we're not going to deal with it.
Well, yeah, but is that not part of this attitude of we're just going to let Congress tax however they want? It's not going to stop them.
It is absolutely part of that attitude, but in the ruling itself, it didn't take a position on that. So, I mean, I see this Justice Barrett decision as opening the door to constitutional challenges to taxation.
Well, I don't think that door has ever been closed, and I think it's ridiculous to suggest that it has been, to be honest. But I'm a minority in thinking that. But so I can't disagree with you, John, on that, and certainly I want you to be right.
Well, Laura, would you go so far as to say that Justice Barrett is our friend in this case?
Well, she's probably more of a friend than the other 5. I don't know yet if I'd call her a friend, maybe less of an enemy.
Okay. Would you say that Justice Barrett is less of an enemy than the other 5?
Yeah, okay, I'll go with that.
Okay, very good. And now we come to the final 2 justices who are really the ones who represent the interests of freedom in America. Justice Thomas and Justice Gorsuch. I think. Now, again, I've got to tell you that, when I think back to the hearing, maybe you remember this. Do you remember the moment where Justice Gorsuch, I don't know, I think it was an exchange with the Solicitor General. They started talking around the issue of whether the person being taxed on the income had to realize the income. Do you recall that?
I recall that being a topic of discussion. I don't know that I recall this specific discussion with Gorsuch. Go ahead, remind me.
Well, that was it, right? I mean, it was an exchange, where Justice Gorsuch is raising the question of whether, all right, assuming there's realization, does the taxpayer have to have realized it, right?
Mm-hmm.
Now, I don't know. I find it. Well, actually, the whole thing is hard to read because it's all so technical. But somehow, in a very quick read, I'm more trouble with Justice Thomas and Gorsuch's decision. But I think what they're saying is that, as a matter of constitutional law, here we go. The beginning of the second paragraph. The Moores are correct. The 16th Amendment incomes include only incomes realized by the taxpayer. There you go. That's the basis of dissent right there.
Yeah, that is the basis of their dissent as far as I understood it. Yes.
Isn't that good?
Well, it's not bad.
I mean, how would the tax academics feel about that, do you think? Club tax.
Oh, they'll hate it. They'll hate it, of course. I mean, they all filed amicus briefs to contest that. So they'll hate that.
Absolutely, they hated it. Absolutely, they hated it. And Laura, would I be out of line in asking you, are the tax profs the friend of individuals?
Oh my God, no.
All right.
They don't care about individuals. They really don't care about individuals.
Yeah, absolutely, they don't, and they care even less about Americans abroad, right?
It's not just that they don't. Well, they do It's not just that they don't care about Americans abroad; they hate us.
You go that far, they hate you. Do you feel hated?
Well, some of them I can point to specific passages that they've written that I don't know if you want to say some people could argue hate is too strong of a word. You could, that's debatable, I guess, but they certainly don't like us, and they
Well,
certainly
I
are
think the
prejudiced
word
against
hate
us.
conveys the general sentiment. Okay,
Okay,
I think it's good enough. I don't think we need, to get out a thesaurus for more words for hate. Let's take it. Okay.
okay,
So, this is very interesting, right? Because this is putting another constitutional requirement on what is income, right?
yeah, that's right.
All right. So, would you say that Justice Thomas is the friend of all Americans?
Well, he's less than enemy, I guess.
Well,
But
isn't this amazing, right?
John, he doesn't
All
come
of the
from a nation
negativity
either.
about Justice Alito, Justice Thomas, and here we have Justice Barrett, Justice Gorsuch, and these are the four who actually are on the side of, oh my God, there might actually be a constitutional limitation on government tax laws, right?
Yes, yeah, that's yeah, yes, absolutely.
So we have four of the nine judges saying that, oh my God, there may be a constitutional limitation on what the government can do. It's going to keep club tax prof up for weeks. They're going to have to go into therapy. Okay. And then we have five judges who are not willing to address the issue. So why isn't this a 4-0 decision in favor of the principle that there may be constitutional limitations on the government's right to tax?
Yeah. Well, I think if you want to be optimistic, that's one way to do it.
Do you want to be optimistic, Laura?
I want to be, John. Whether I will be is another question, but I do want to be.
You sound like a lawyer.
I'm so sorry.
It's okay. It's okay. You spent a lot of years being a lawyer or something?
I think I've been a lawyer more than half my life. Well over half my life, in fact. Yeah. So
And
what
what do
can
you
I
think it
say?
would be like today if you hadn't spent more than half your life as a lawyer? What do you think? How do you think your life might be different? Do you think you'd
I
be
don't know.
positive?
I don't know. I think I'd probably be the same person. I just probably wouldn't have a certain I wouldn't have been taught certain ways to think about things and express things, but I think I'd probably be the same person.
Okay, well, that's good because there's a lot of people who've been so corrupted by becoming lawyers that they can't even recognize themselves anymore. Well, anyway, that's sort of my take on this. With a quick read. I mean, what do you think of my take on this, or what do you want to add?
I think your take on this is very interesting. I agree, and it's given me some interesting things to think about. So thank you for that.
Maybe Seat should write a blog post. Supreme Court issues 4-0 ruling in favor of individual taxpayers.
John, I will read that with great interest after you write it.
Well, that's what I think it actually is here. I mean, I know that, to put another way, I mean, it's a loss for, well, the Moors were never in this anyway, right? I mean, it was a loss for, the group who wanted to use this case to somehow create a judicial impediment to certain kinds of taxes, right? But oddly enough, although I hate the decision from the point of view of how it affects Americans abroad, I really do, and I think they really need to renounce. I actually could imagine Justice Barrett being quoted 30 years from now. You know, that passage where, you know, after it's gotten so bad that the US has tax prisons, you know, and things like that. And, you know, the decision is used that a certain tax or whatever is unconstitutional. So I don't know. I mean, it's interesting. I'm not surprised by the result, by the way, at all on this. Are you?
No, no, walking out of the hearing, it was pretty clear that this, you know, without knowing what the substance of the argument was going to be necessarily, it was pretty clear this was going to be the result based on the attitude of the justices and the questions they asked. Yeah, I can't stop thinking about how Thomas looked like, you know, he was leaning back in his chair, and, you know, most of the hearing, you couldn't tell whether he was awake or not.
Well, you know, Justice Thomas is, I think, the most principled judge on the court, isn't he? I mean, you know, he doesn't need to be confused by a bunch of legal arguments.
You could argue he walked in there already knowing what he thought. Yeah. Yeah, sure. Well, they probably all walked in there already knowing what they thought, but I guess
Well,
he
clearly
thought
so,
he didn't
clearly
need to,
so, clearly so.
but he didn't need to pretend otherwise, I guess. I don't know. It could be that he was awake. Who knows? You just couldn't tell.
You think he might have been awake?
Well, I mean, I'm sure at least part of the time when he was leaning back in his chair, I'm sure he was awake, because I'm sure he had periods of, if he did sleep, he would have woken up and gone back to sleep and woken up and gone back to sleep. But I'm sure that there were periods when at least his mind wandered and he wasn't listening, if he wasn't actually asleep. I'm sure of it. But, you know, how can I really know? I can't know. But it was just the contrast, because, you know, he turned his chair to the side and he pushed it back. And so that, you know, his chair was in a reclined position. And you can't see his face, but you could see the position of his body.
Well, it was sort
And
of like, to use a flying analogy. It was like he was flying business class. He had a nice chair and he just sort of, you know, reclined it a
yeah,
bit.
yeah, just pushed it back and,
Sat in
you
for the
know,
ride.
like he was along for the ride. Exactly. Yeah.
Anybody offer him a drink or anything during the hearing?
Frequently people would just come with drinks. I don't know if they were being asked for or not. I mean, I wouldn't have remembered exactly who got drinks, because that was pretty common that people were getting drinks.
Any other ones sort of, you know, generally flying business class, you know, just lying back enjoying the ride?
Sometimes Alito looked like he wasn't necessarily paying attention, and sometimes he would talk to Roberts. They would have little side conversations. Not too often, but they did do it, and it was a contrast to most of the others who basically did not do that. I mean, maybe occasionally they did, but not enough that, you know, I would have retained it and remarked on it and remembered it and remarked on it.
So when you look at the alignment on the decision here, does any of it surprise you at all? I mean, just based on, you know, we had a discussion about this the same day as the hearing where we talked about it, but do any of the alignments on this decision surprise you particularly?
Well, I would have more thought Alito would have joined the dissent. I'm a little surprised that he's, you know, in this concurring opinion. I was a little surprised by that. Otherwise, no, I guess I'm not that surprised. Just by Alito's decision, that's all.
Yeah. Well, you know, it's as interesting as it is, this decision is an absolute tragedy for individuals in America. It's an absolute tragedy. And, you know, it's magnified, right? You know, 1,000-fold for US citizens living outside the United States. All
it's very frightening, because, like I said, I don't think we're going to get any solutions from Congress. Congress is the source of these problems, and it's really ridiculous to think that they're going to be the solution to these problems.
Well, they're
which,
not going to
you
be the
know,
solution unless, people make it clear that what's needed is severing citizenship from tax residency. That's clear.
well, we have a hurdle before we can get to Congress, which is ourselves. And that hurdle, I honestly don't know if it can be overcome. I've become very pessimistic about that in the past few weeks.
Well, the biggest barrier to change for Americans abroad is Americans abroad. That's been clear to me for, a long, long time. And it's partly because, not all of them are the same. The interests of expats, retirees abroad are so different from long-term residents abroad. It's also that, this stuff affects those who it does affect very, very differently. It's a complicated issue that almost nobody really understands that well. And if they can get their situation fixed, they're generally happy with that, regardless of, anybody else. And, I have come to see that it's really a minority of American citizens who don't, I think, who really oppose citizenship taxation. I think the rest of them really love it. It's part of their identity. I don't think they could imagine themselves, even existing without, being defined by U.S. rules, etc. I mean, it's unfortunate, but that's what I think is going on, right? I mean, and then they get into this whole voting issue. Oh God, I mean, like, how can anybody seriously imagine that going out to vote for the same party is going to solve this? But, whatever. What do I know, right?
So, what's the point of all this?
What's the point of all what?
Well, I mean, why? If so many people, John, think so differently from us, and we're such a minority, what's the point? Why don't we just say, you guys win?
Laura, the point is that in this world, there are things that are right and there are things that are wrong. There are things that are moral and there are things that are immoral. And at the end of the day, people should not be behaving, based on the behavior or thoughts of other people. It's like, back in the old days, former Attorney General Ramsey Clark, made the statement, I mean, the last place I would go for my opinions on things, are criminals and this type of thing. I mean, the last place I think that you should go, or any principled person should go to decide what they're going to do in life is, it's what a bunch of unprincipled people think. So the
Yeah,
reason
but
to do this is because it's the
they're in the
right thing to
way.
do. What?
But they're in the way. They are stopping you from doing anything. I mean, there are people that disagree with our position, but they're not in the way. They're just, off living their lives. And then there are people that are actively in the way.
Laura, look, I mean, I could say any of a number of things. Why don't I try the difficult we do today, the impossible takes a little longer. Okay? Look, sooner or later, I mean, this is so immoral. It is so unjust. It is such a travesty of justice. Sooner or later, people will wake up, to what this really is, and there will be change. I mean, look, you got to do something in life. You have to stand for something. You might as well stand on the right side of these issues, don't you think?
Well, I mean, there's I'm going to paraphrase something that I hear often. You fight something that is wrong, not because you think you'll win, but because it's wrong. I'm
Yeah,
paraphrasing another.
I think that makes,
But
yeah.
but it takes a lot of fortitude to do that.
Laura, you got to spend your fortitude on something. Why not this?
Uh, all right, John. Well, thank you for the opportunity to talk about more.
Are you happy with the decision, Laura?
Well, no, I can't say that I'm particularly happy with the decision. No.
It was a 4 to
You-
nothing decision in our favor.
Yeah, okay. For that small aspect, 4-0 decision in our favor. Okay. 4-5 decision in our favor.
4 to nothing. The majority took no position.
Yeah.
It's that it's 4 to nothing. Okay, it really is. I mean, can you?
Okay.
The next generation of law students are going to be holding up Justice Barrett, Justice Thomas, Justice Gorsuch, and Justice Alito as the great defenders of human liberty.
From your lips to God's ears.
Well, it's true. And for those who are thinking of voting Democrat, let me remind you that every judge appointed by a Democrat voted against individuals and against Americans abroad. Keep that in mind.
Yeah, that's true. That's absolutely true. And on this court, I don't see that changing anytime soon.
I think that's right. So if you want more justices like Justice Barrett, vote for a Republican.
Gorsuch seems to, well, he still could have done a little more in this decision, but at least he wasn't the worst.
Well, he wasn't one of the 5 in the majority, so he wasn't the worst. I mean,
All right, John.
Justice Gorsuch is going to come, is in history will remember him as possibly the most activist and one of the greatest judges the court has ever had. I mean, he didn't do as good of a job as he could have in this case. But don't forget, okay, that he stood up for Americans abroad in the F-bar case. He stood up for residents of Puerto Rico, when the majority was saying, nah, people in Puerto Rico don't have rights.
Yeah, that's why I had higher expectations for him on this.
I agree with you. I was a little disappointed, but hey, he was not one of the 5 in the majority. Why don't we call them the Kavanaugh 5?
Okay, let's do that.
Kavanaugh 5. Yeah. We can look at it this way. But I mean, Gorsuch was Kavanaugh was a disappointment.
Yeah. Yeah. All right, John.
All right. Okay. And we got to get this in. And where do people go to read the collected works of Laura Snyder?
Well, okay, if you want to read about what we had to say about more, there are 2 articles that are out there. There's an article that you and Karen and I wrote called, what did we call it? We called it Don't Blame the Victims, Individuals in the MRT. And there's my article, The Invisibility of the American Immigrant. You can get links to both these articles on the SEAT homepage, Stop Extraterritorial American Taxation, seatnow.org homepage, scroll down. You'll see links to all our articles.
What about the SEAT amicus brief? Where do they find that?
The SEAT amicus brief is on the Supreme Court's, the docket page for this.
Is that not on the SEAT site?
Oh, it is actually. It is on the SEAT site. Let me remember what page it's on the SEAT site. I forgot we put that on the SEAT site.
I think it should be very easy to find, given all the presumed interest and more.
Okay, there is a SEAT submissions. There's a page, SEAT submissions, and that lists all the submissions we've made for different congressional hearings to the State Department, and then also there's a link to our amicus brief. Thanks, John. I forgot that was there.
Don't you think you should change the blog, okay, so that it has a category for amicus briefs?
It's not the blog, it's a page for SEAT submissions. And we only have one brief So
That's
it would
okay,
be all
that's
by itself
okay,
on a
that's
page.
okay. That doesn't say amicus brief. We can add the S when the next one gets up there.
Well, okay, tell you what, when we do another brief, I'll put them on their own page, but I'm not going to put it on its own page for now. Not when it's just one.
Okay,
That's just-
Laura, okay. Then we have to do another one, I guess. God, you can be so difficult sometimes.
Sorry, John.
It's okay. All right, Laura, I guess
Oh,
we'll,
and doing survey. If you haven't done our survey, do our survey. Links to the survey also on our website homepage. At the there's a link and there's also a blog post about it. Please do our survey if you haven't. Thank you, and please ask others to do our survey. All you have to do is be an American or former American who lives outside the United States.
Laura, you are working for Americans abroad 24/7. Do you even
I sleep sometimes.
do you-
I do sleep sometimes. Yeah.
How much? When did you
Well,
last?
we'll talk.
When did you last sleep?
Oh, I slept last night. Let's talk about that in another podcast, John.
Okay, Laura. Tell you what, thanks very much for the discussion. It's been a lot of fun and educational as always. But you know what
Thank you, John.
I suggest to you? Get some sleep.
Sorry?
I'd like
Okay, I'll get some sleep.
get
I
some-
will. I will.
Okay, Laura, have a good sleep. And I want
Thanks.
you dreaming of more. You dream of more.
Okay. More of something.
Okay, Laura. See you later.
Bye, John.